This message comes from Legal Talk sponsor Choice New York Management.
Buying and selling a home should be exciting. We know it's the biggest transaction most people make, so our agents are laser focused on the details while keeping it fun. Let the experts of Home by Choice deliver the best possible results for you. Our approach is simple. Your home is our priority. Visit homebychoicenyc.com for more info.
Welcome to Legal Talk, a conversation about governance issues that New York's co-op and condo boards are tackling today. I'm Carol Ott with Habitat, the New York City magazine for co-op and condo board directors. My guest today is Evan Richman, a partner at the law firm Fleischner, Potash. The pandemic has transformed the co-op and condo landscape for board elections. What once was a physical event held in common spaces and building basements all across the city has now shifted to a virtual one. But with this shift comes a new challenge. How do you verify that people voting are who they say they are? Evan, you were litigation counsel for the board of the landmark condominium in Portchester that involved this very issue. Can you tell us what happened there?
Sure, Carol. So as you mentioned, the landscape in the condo and co-op world is shifting, with boards now shifting from in-person annual meetings to virtual and electronic meetings. So I was recently involved in litigation, as you mentioned, where this issue was kind of at the forefront. It was a condominium in Westchester. It was a disputed election between two different slates of candidates for the board of managers. Right before the election, the board had issued a notice to all the residents in the building, letting them know that this meeting was going to be done virtually, electronically over a platform, and advising them that in order to vote in the election, the board was going to have a new requirement that each resident or member had to first specifically authorize the email address from which they would be sending their directed proxy at the time of the annual meeting. And the board provided each of the members with an email authorization form, which was essentially a simple form that required the member to list their name, unit number, a specifically designated email address from which they would be sending their proxy, sign it and date and send it back to the managing agent. That was the requirement. However, at the election itself, it appeared that a number of proxies were submitted, but there was no prior email authorization that was on file from the board or the outside accountant that was retained to monitor and oversee the election. So when the accountant looked at all the votes that came in and tried to match them up with the emails, it turned out that there was only about 19% and 50% was required for quorum. And since there was no quorum, there could be no election, and the board that was already in office continued for another year. And this then led to an election challenge from the side that had been had submitted the proxies. And
let me just clarify, the problem with those proxies was that there was not email authorization?
Correct. The requirement that the board imposed was that in advance of any of these proxies being submitted, each resident or member had to specifically submit this email authorization form designating a specific email address from which they would be sending it, so the board could have verification that when this proxy came in, they can match it up against the specific email that was on file, so the board would have peace of mind that the individual submitting it was actually who they said they were.
And so what was the outcome of the case?
So we went into litigation. The petitioners were basically arguing that this email authorization form wasn't reasonable, shouldn't be permitted under the new amendments to the BCL. And at this time, the condominium was under the not-for-profit corporations law, and that it should be stricken regardless of the recent amendments. However, the court held that the board was required to make steps to verify who these individuals were. The board was required to impose safeguards on these elections, and the court held that this simple email authorization form was indeed a reasonable requirement and was valid under the statute, and the court dismissed the case.
So going forward for boards, what should they take from this case? What is the significance to boards as they hold their annual elections in the upcoming years?
Right. Well, I think this is a very significant case because it appears to be the first case in New York in which a court is interpreting what this verification requirement means under these newly enacted statutes that just came down as a result of the COVID pandemic. And as both co-op and condo boards now shift from in-person meetings to virtual and electronic meetings, this issue is going to be in the forefront more and more over the coming years. And again, a requirement of the statute, the board needs to impose some type of reasonable safeguard. And I think this case is significant because it established as a matter of law that a prior designation of an email address constitutes compliance with that statute and gives the board peace of mind that if they do this, then they fulfill their obligations under the law.
If a board doesn't do this, or if a board just says, we're going to have our annual meeting, we're going to hold it on Zoom, it'll be this date, we're going to vote for board directors, and doesn't take any precautions, what is the risk?
Well, I think, again, it's a case-by-case scenario. You have to determine exactly, what are the facts on the ground that are pertinent to your co-op or condo. But as we're moving to a virtual world with everything, there needs to be some type of safeguard, some type of safety net in place to ensure or to try to eliminate any types of fraud or people doing, misrepresentations or things that they shouldn't be doing. So if a board decides to kind of ignore this completely, then I think they potentially open themselves up to some type of risk or some type of election challenge or headaches going down the line.
And to sum it up, aside from the email authorization, which I actually think was a pretty clever idea, are there other methods that you think would be considered reasonable?
Right. So I think, again, this is one form that is a simple and non-onerous form which a board can do, but certainly by no means is it the only form. We're of a different board that submitted a unique identification code to each member in advance of an election, and they needed to submit that unique identification code on the proxy. So again, the board had peace of mind that everything was in order.
If you haven't had contested elections, do you think it would be necessary to take this extra step?
Well, I think it's just good business practice. It makes sense for co-ops and condos to kind of go the extra step, and especially with something that is not significantly difficult to do, to ensure that there is verification on each side. We get this all the time. We try to log on to a website and they text you a code and you got to make sure you submit the code. It's the world we live in. And I think it kind of makes good business sense all around, even if the idea of a contested election isn't at the forefront of your mind.
Okay, very good. Thank you so much. I think this is really useful advice.